Hello, everyone, and welcome to Healthy Living Interviews. I'm your host, Dr. Andrew Kaufman. And today I have a returning guest, a very exciting individual who has garnered a lot of enthusiasm in the law community and kind of the study of real law outside the bar system or bar card system, as he puts it. Once again, welcome Brandon Joe Williams. Hey, Brandon.
Hello, hello.
Good to see you again.
You too, my friend.
We had some fun in Texas, and you've been on a roll since then, haven't you?
Oh yeah, never stops. The party all day, party all night. You know what
And
I
well, I mean, I was just talking
mean?
about work, but of course, I know what you
That's
mean. I know
work is party. Work is
the
party.
drinks, the women, the luxury lifestyle, right? The
I
fast
suppose.
cars.
I
It's
suppose motorcycles for sure.
yeah, well, both, right? Anything on wheels.
Yeah. Southern
So
California and motorcycles go together really pretty much. It's pretty much the greatest combination I've ever experienced in life. So yes.
that's right. I mean, they even have statutes that are favorable there, right? Like lane splitting and helmets and such.
Yeah, I mean, we pretty much. I mean, it's completely lawless on a motorcycle. The cops don't mess with you. You can park anywhere. Parking's typically free. You can lane split. Yeah, it's. I don't know if it's just everyone thinks that we're suicidal, or just, I don't know what it is, but for whatever reason, yeah, the it's beyond. Yeah, we pretty much are. Yeah,
I wonder if the riders there have a better skill set than in places where these things are.
I would say so. I mean, I grew up in Indiana and I spent a lot of time in Florida and I went to Texas recently and you see a lot of Harleys. You see a lot of people that have bandanas on their head, no helmet. You see they're just kind of cruising around with their buddies. They're just having a nice day and enjoying the sounds and smells of the world on a motorcycle with their woman on the back. And they're not, out here in California, you don't see a lot of that. Even the guys on the Harleys are crazy as fuck going 90 miles an hour in between the cars. Um, so yeah, I would say if I had to say skill level here is probably way beyond what you would normally see in the rest of the country. But it's also there's not a lot of people cruising around with like sort of an enjoyment aspect of riding. There's a lot of it's a lot of very intent driven. Let's go, let's go, let's go. That's typically what you see on with the motorcyclist.
I see. So it's get from point A to B as efficiently as possible,
Yeah.
and that makes sense with this sort of fast pace of life that one might associate with Los Angeles.
Yep.
So, Brandon, unfortunately, we're not here to talk about speed, booze, and women today primarily, but we are. We agreed in advance to talk about litigation and specifically pretrial motions, motions to dismiss, and motions for summary judgment. So, I thought we could just start with like kind of the basic beginning of a lawsuit and like the sequence, because these things are going to come in right pre-trial, but they can come in at different points. And so, to review, we have the first document is the complaint. So whoever is the plaintiff or initiating a lawsuit, they file a complaint which states the facts and the cause of action. In other words, why did the other party wrong them and owe them money? We're talking about civil cases, right? So it's always about money, or it could be, they need to do something like we need to prevent them from building something like an injunction, or have them do the job that they're supposed to do, perhaps according to a contract. And then after the complaint is filed, typically the party who's being sued will have a certain time limit to answer. And in their answer, they can defend against the claims in the complaint. And they can also file counterclaims, which means they're kind of like countersuing. But before they do that, they have another option. They can actually file a motion to dismiss. So, Brandon, why don't you tell us what the basics of a motion to dismiss are, if you don't mind?
Yeah, they're pretty much always going to do that, no matter what, unless you're asking for $1,000 and it's going to cost more to actually put together the motion to dismiss than it will to just pay you. But basically, what they're going to do is they're just going to say whatever. they're just going to kind of put whatever and do whatever and just kind of make stuff
Right. So
up,
this is like a way to just get rid of the lawsuit, right?
yeah,
Right off the bat.
it's just a kind of a frantic horseshit attempt to just kind of throw you off, especially new people and pro se people. And it's very effective, actually. Most people do get thrown off by it, and they don't know how to handle it, and they don't know how to answer it, and they think that they're going to be able to just file this complaint, and they're just going to sail into the sky like Peter Pan. And then when they get the motion to dismiss, the response, it bursts their bubble very rapidly, and that's because it's delusional to think that you're just going to sail off into the sky like Peter Pan. You're going to be banging on this wall. So the simplicity of all litigation, and it's very important to understand this when it comes to that first dismissal, is that you're standing in front of a door and you're banging on it and you want the door to open. These people called bar carts, their entire job essentially, if you have any substance to your complaint at all, is to redirect your attention away from the door by all means necessary. Dancing girls, naked girls, flowing fountains of honey and whiskey, shiny objects, anything they can possibly do to sway you away from your fixed dedicated glare on that door is their job. And that motion to dismiss, which they're always going to do, is their first attempt to do what they're supposed to be doing. And that's essentially, in their own mind, that's the definition of what the bar card's supposed to be doing. The bar card is supposed to be redirecting attention, confusing attention, or reducing or diminishing attention, intent, and focus. That is all they are trying to do all the time. And when you realize that, it's very easy to combat the situation. If you don't realize that, you will find yourself confused, drowning in some lake somewhere with fake titties that you thought were there that were never there. And it's like being dehydrated in a desert and then waking up to the fact that there was no mirage and you're about to die.
So I think, Brandon, like this is such an important point because especially if you're a pro se litigant, right? And now you were really describing if you're the plaintiff, right? And some bar card is the defense, that they're going to use this tactic on you, but it can actually work either way. Even if they're the plaintiff and you're the defendant, they can essentially do a motion for summary judgment, which is really a motion for a default judgment, right? Which is just to get their way without you having any chance to argue. And these are both very frequently used as tactics just to, intimidate you, threaten you that you think, oh, your lawsuit is just going to go away. Like if you can't stick up to it, the way they write it sometimes makes it seem like they actually have substance to their argument. So in order to, deal with this, I think the first thing you said, Brandon, is, you got to not be intimidated by it and realize that most likely this is only bluster and there's not actually substance. And then I think you should know what the actual substance is, because a motion to dismiss can be legitimate in some circumstances, and you could be the defendant. So you could use a motion to dismiss in your favor, or you can even use it as a tactic also, because it means the other side is going to have to pay more billable hours to their attorney. It's going to delay their ability to get, a resolution to whatever their claim is. So it can work in your favor both ways as long as you know how to deal with it and understand what it is.
Yeah, and just so that everybody who may not be familiar with what I do, I go after financing companies, and I do like a very very advanced style where I've gone very deep into how a lot of the funding occurs for a lot of these so-called loans. They aren't loans. And so I'm the plaintiff. I'm very aggressive, and the defense and the judges and pretty much everybody involved, they don't really understand how all of this works. Very few people actually understand how all this works, and it took me a long time to even have the slightest grasp. So everything I'll be saying during the show is from the point of view of I'm very aggressive. I know the information better than anybody else in town because I didn't. It's like going into a firefight after having been in really intensive training for many years, I don't have a concern with my ability to perform during the firefight. And then the defense either having no clue what's going on, or maybe having a bit of a clue and just trying to redirect the conversation away from the facts on purpose, trying to derail the case. So when I talk the way that I talk, it's all based off of a lot of this stuff. And anyone getting sued for any financial situation, such as a mortgage default that's going into a foreclosure, such as a business loan that was not paid upon, and they're suing you for it. Anything that would have been collateralized, such as a car for a car loan, or a house for a house loan, or anything else for any other sort of personal loan. These kinds of situations are all the kind of thing that I specialize in. And when you understand how all of that works and how the funding works and how all those things work, they don't stand a chance. And no one understands how any of this stuff works. So when you start bringing it up, they just start freaking out and redirecting and shiny objects and mirages and titties and whiskey. And it's not even a good attempt. It's not even like they're trying to find out what I like, and then they're going to present to me what I like. They're just like, oh, maybe he'll like this, and it's like a black cherries from Sweden, and I'm like, you guys haven't even. It's just like, it's absolutely ridiculous. It's like children. It's like anyone who's a parent who has dealt with children throwing temper tantrums. If you're any good at handling those, you'll be great in litigation.
So Brandon, it's so funny. We have, I think, the same experience, because this is what is going to happen when you go into court and you know what the law actually states. And you're right that the other parties are going to, play ignorant to this, even if they have some clue. The judge, I think most judges are going to actually understand this to some degree, but they're not going to be very willing to go there. They're going to resist it, right? So in one of my lawsuits, okay, I was basically started using negotiable instruments to settle my credit card account. And they apparently didn't really respond. They pretty much ignored me, right? They were in dishonor. I know you've been recently studying negotiable instruments. So they ended up suing me, like in a consumer debt case, saying that I had a debt to them, right? So without getting into what's going on with loans and money and the banking aspect, here's what they wrote in their motion for summary judgment. They wrote, they just didn't receive anything from me. Like, I sent all the negotiable instruments, accountable mail, registered mail. They were sent to multiple parties. There were, I think I counted somewhere between 15 and 20 total pieces of mail. In their own policies, it says to send your payment in by first class US mail. And even in the affidavit from their executive, they said that they use first class mail as a normal course of business. So then they're saying, oh, grant us the case because even though he has proof that he sent all these things, we just didn't receive any of them.
Yeah, well, the beauty of that situation, I mean, again, litigation is so the simplest way to think of litigation, in my opinion, and I'm fairly new. I mean, we've been involved since about February, but all day, every day, that's how I do things. So 4 months, you can learn a lot about anything in 4 months in full immersion, right? So so people aren't aware. So everything in all cases, pretty much. Let's say, for example, there's like a medical information about a child or something like that, or let's say there's a few specific things that would be retracted from the items that would be filed into the docket, to where only the judge and only certain parties could even see that particular piece of information. But 99.9% of everything, basically what you're dealing with is a public UFC style octagon battle. That's what you're dealing with. And people can be tagged in and people can be tagged out. And it's a battle of wits and logic and what is written and codes and morality and all of these different things. And it is a full on public display. There's something called Pacer for people who are not too familiar with how any of this works. And you can get in there and you can type in someone's name. You can type in the name of a business. You can type in the name of an organization. And as long as you have some idea as to what court they might be in, and even if you don't, you can kind of chicken peck around and find it anyways. You can actually pull up the entire docket. For example, I on a show one time, I pulled up the entire docket for Wesley Snipes' first case, not the appeals case, but the first one. It was 602 filings into the docket. So what happens is you'll have the first, it'll say 1, and then it'll have a description of what that particular filing is. 2, 3, 4, 5, 602 filings. If you click on the little number, it'll say this particular document is 20 pages. It's going to cost you 10 cents per page to download. It's $2 total. Do you want to download this? You say yes, and then it pops up and it'll have a PDF and it'll be downloadable as well. And then for people who don't want to spend that kind of money, which it's really not that much, every quarter, if you spend less than $30, it's just free on Pacer. Okay. And if you really are worried about that kind of amount of money, which is very sad, you can use what's called a recap, which is from the Free Law Project. It's a little browser extension, and every time someone downloads anything from Pacer, it automatically goes into this thing called recap automatically. And then anyone else using recap can then download that same item for free. So it becomes crowd shared as soon as it's downloaded by one person. I don't use recap just because I'm trying to immerse myself in Pacer as much as I can on purpose to try to, again, immersion's a big part of my life and what I do. But I wanted to mention that as an available second option. So you are in complete public warfare. You are battling inside of an octagon. There are people watching. Hell, for all we know, there are people betting on it. So that is essentially the definition of the word litigation, in my opinion. It is UFC. It is this new. I don't know if you saw that new one where they have the full blown knights now. They have an octagon just like UFC, but they're in like full blown medieval knight, and they have swords, like real swords and shields. Have you seen that?
No, it sounds cool though.
Brand new. So litigation is essentially the same thing. People just don't know that, but that's essentially what it is.
No, you're right. I mean, it is very adversarial, and many things are, strategical tactics rather than things that are trying to really genuinely pursue justice. And when, in the bar card world, I mean, so much of it is about the billing, right? How can they generate more billing hours and, get more clients? So, it's different for us because, we have skin in the game, or we're doing this, to expose some of the greed based fraud and, other systems, because I think the real law is actually quite favorable to us. We just don't know how to uphold our rights in these transactions because we don't understand what's really going on. And the same thing, I mean, even, I'm a little bit intimidated by litigating myself, especially, when it's my personal finances or my personal property on the line. But once you get in there and you see and you start doing, you realize, this is, as long as you know and you can think, you can start to realize that they're just doing stuff that doesn't really add up. And as long as you can respond to it properly and also preserve the evidentiary record for appeal, that is key to anyone doing the kind of stuff that we're doing with yourself, which just means you have to get it on the record when you call them out doing something that's wrong. So if they give hearsay evidence, you have to call that out, right? If there's evidence that's prejudicial or inadmissible for some other reason. So you do have to learn some of the rules, like the rules of evidence. And, there is, of course, the great jurisdictionary course that covers the basics of all this. And I think you need something like that before you start filing documents so that you know what you're doing. Because sometimes a motion to dismiss is legitimate on the grounds of what's called either failure to state a cause of action or failure to state a claim. And that means, like you have to, when you write a complaint, if you're going to sue someone like Brandon does, you've got to know, okay, what is there a legal remedy, right? Is there something in the law that says, they wronged me in a way? There's got to be something tangible you can point to, that would get you damages. And of course, you have to have at least some facts to back up that that is what happened. And some people, I think, get really so worked up emotionally when they're wronged that they don't fully think through. Like I had someone talking to me who was trying to figure out how to get remedy, feeling that his rights were violated by the police, but he wanted to like say that the police lied to him and sue them based on that. And I'm like, there's no cause of action. The police are not only allowed but encouraged to lie to you to get you to do what they need you to do, right? So that's not going to survive a motion to dismiss. But there could be other things that they did that actually do violate something like it, right? For example, if they forced entry into your house but didn't have probable cause, then that actually is a cause of action that you can state, and the court can't dismiss that outright.
Yeah, the police stuff is interesting because you have, just like in all litigation, you have duty, breach, damages. That's the three areas that you really have to focus on whenever you're doing any of this. So the first thing you have to establish is the duty of the person that you're suing. So let's say, for example, you did want to sue a police officer, right? So a good example of that would be, let's say, on the side of the road, and the police officer says you need a driver's license to operate a motor vehicle in state of California. That statement is entirely true. Now, let's say, for example, you don't have a motor vehicle. Let's say, for example, you have an automobile, which is a completely different terminology. The assumption that you have a motor vehicle is the assumption that is the underlying assumption in terms of the duty he feels he needs to now take, right? So if he had this underlying assumption that you are quote unquote driving a motor vehicle when you in fact were not, you were actually inside of an automobile, which is a completely different thing. Then the thing is that his initial assumption, of which equaled his duty, it has been blown out from underneath him. So what happened is that he didn't have the duty. There was no duty. So the breach was the fact that he thought he had a duty. You tried to explain to him that that isn't the situation at all. You actually have an automobile and not a motor vehicle. He continued along that line based off of his assumption that had no evidence to support such an idea. And then now we have a breach, and then now we have damages. And the area in law that would be very effective to go after something like that, and you see it quite often being used in a lot of litigation, is 42 USC 1983. It's called civil action for deprivation of rights. There was a duty that the police officer thought he had a right to deprive you of certain privileges and immunities because he was under the assumption that you were inside of and driving something called a motor vehicle. Once that assumption is attacked effectively through evidence and through clear, the situation is too is it's very interesting is that the person making the claim is the one who has to prove the claim. So if the officer has decided he would like to press forth a claim defining said car as a motor vehicle, the easiest response to that is not to go off on a manifesto about automobiles versus motor vehicles. The most effective way to defend that situation is to say, okay, so you're saying that you had a duty based off of this idea that I am driving a motor vehicle. Yes, that's correct. Great. Now, I will open the floor for you to prove that said car or truck was in fact a motor vehicle. That's all you have to do. It's very easy. You just set them up and they just fall right off the stage. You don't need to do a goddamn thing. Now, as soon as they fall off the stage, it's very, very easy. You can simply dismiss them as an incompetent witness. Everything that they say and everything that they're doing in the situation is all horseshit. They don't even know what the hell they're talking about. They don't even know their own duties. They don't even know why they're there. They're in this costume and they're on the side of the road, and they literally don't even realize that they have no idea why they're there. Now, at that point, countersuing becomes very, very easy. You have someone who essentially at that point has no clue what they're doing. They have no clue why they're there, and now we start getting into deprivation of rights and all sorts of good things. But the way that you do it is it's very, very calm. It's very, very calculated, and it's based off of the way that these things work. Which the simplicity of it is duty, breach, damages. It's very simple.
So, Brandon, let me just clarify. Are you talking about like the scenario where you get pulled over in a traffic stop, but you don't have a license or a license plate on your car, and maybe you hand the officer a passport or some other document that you prepared yourself, but you don't engage? Maybe you don't engage in talking at all, or maybe you just talk to him man to man, but not like as a police officer, or
It
maybe
could
you
be
just
it could be anything of the above because
and
the thing
then
is
you get
they're going to make three assumptions. They're going to make three very, very serious assumptions. And the thing is that if you don't rebut these assumptions become basically contractual. That's the way everything works. If I say you live in Mexico and you never say anything back to me, technically speaking, in law, now you live in Mexico, which is, I know is fucked up, but welcome to planet Earth. They're
Well,
going to
is
make
there like that's a key point, right? Because we can use this in administrative process all the time to establish contracts. So
yes.
is there a name for this principle that like would you say assent?
Yeah, acquiescence or however you want to say it. But if you already have a contract, like for example, I send these things out all the time, knowing that they'll never respond. Same thing they do to us. You start studying how all this stuff works and what they do to us. You can do all the same shit to them, and it'll work just as effectively as how they do it to us. So it's called a novation. A novation means a change in a contract. Like when you're using Facebook and it says if you continue to use Facebook, you agree to the new terms and conditions. You can send brand spanking new, totally handmade terms and conditions to absolutely anyone, the DMV, the Department of Justice. You could send, and the thing is, if they don't respond to it, that becomes the new terms and conditions of the contract. It's actually hilariously simple, right? I'm doing it all the time now. I send out novations constantly. It's hilarious. I'm sitting here giggling like a madman because the thing is, I know they won't respond. So as soon as they don't respond, boom, the contract now shifts to the new terms and conditions that you have placed on the documents. Okay. But back to what I was saying at the traffic stop, right? When I just finished that thought. So the police officer is going to make three assumptions. He's actually trained to make three assumptions. The first assumption is that you're driving. In Title 49, the definition of driving is any person who operates any commercial motor vehicle. The word person has a special definition. The word operates has a special definition, and the word commercial motor vehicle has a special definition. So he's assuming a word called driving, and he's also assuming the definitions of all three specialized terms used inside of that definition. Okay. The second thing he's going to assume is he's going to assume that you are inside of what's called a motor vehicle. The definition of motor vehicle is a vehicle that is being used to transport, and they use three different terms: cargo, persons, or property for some kind of fee, rate, charge, or other consideration. I think I might have missed like one word in there somewhere or something. So that's the second assumption they're going to make. The third assumption they're going to make is that this transaction of them on the side of the road with you, with this so-called motor vehicle, is actively taking place inside of a business listed on Dun and Bradstreet called State of California. So the thing is that if you have three major assumptions that build what the officer believes is his duty. Now, those are the three pillars that his idea of duty are basically held upon. And when you blow out those three pillars, which is very, very easy to do. In fact, you almost need to do literally nothing. You just ask them one leading question and they just fall over and die right in front of you. It's the easiest thing in the world. Now, once that duty has been proven to be completely asinine, like the most delusionary duty anyone could have ever imagined in the whole world, it's not a motor vehicle, it's not driving, and it's not in the state of California. Almost the entire statement is literally completely fictitious. Now, at that point, now what you have is you have a breach, and then now you have damages. And then that is the structure of how you will structure a situation like that.
So now that you're not saying though that you would file a motion to dismiss against a traffic ticket.
I would actually file a counter complaint and start going after the officer, because the dismissing a situation like that is just way too easy. If you don't turn around and attack the source of such asinine assumptions, they are going to continue to make those assumptions with other people on the road. And the thing is, there's two points to this. First point is, that needs to end, because that's completely insane to go around making all of these ridiculous assumptions. The second thing is, so there's a morality aspect to it, right? The second thing is that your time was wasted, your family was upset, you experienced anxiety, you had a breach, then which occurred damages, and you deserve justice. Justice is a balancing of those scales. Okay, so there was a fake duty, totally insane, like absolutely delusional, like someone walking down the street on PCP and LSD, and they're just whacked out of their mind, and they think it's their duty to paint the chest of every person wearing a white T-shirt, and they're just running around screaming like a raging lunatic, with vomit all over their beard, and they're just trying to paint everyone's white T-shirt. Like, oh, it's a white T-shirt. I gotta paint the white T-shirt. So they're just running around doing this, and people are saying like, whoa, get away from me! And there's red paint all over their T-shirt. No, this individual needs to be corrected. This individual needs to realize that they're not supposed to be going around painting white T-shirts with red paint. Okay, so that's the morality aspect of the situation. The second aspect of the situation is, there's been a breach and there's been damages. Why should there not be a balancing of those scales? And why should you not be paid or compensated for your time and your energy and the annoyance of having to deal with someone making such ridiculous, insane assumptions and trying to paint your white T-shirt with red paint like a lunatic on the side of the road?
All right, Brandon, I think I understand what you're saying here. What you're saying is that they're acting as if you have a contract with them when you don't. It would be like if a doctor that wasn't your doctor took you off the street and put you in the OR and did bypass surgery, right?
You
And
got
you're
it.
like, what the hell? You're not my doctor.
Yeah, that's
Because
right.
you're saying like I didn't make a contract with DMV or with the state of California,
Precisely.
so I'm not subject to that contract. Therefore, you have no duty to me when I'm traveling, and it's an infringement of my rights if you try to impose that upon me. And that totally stands up. But let me ask you this question, because I think the idea of novation is very compelling. So, what about this? Let's say that you originally had a contract, let's say with a bank, regarding financing contract. And then you filed a novation that they didn't respond to, but you amended the contract.
Yes.
Now they are suing you based on the original contract, but their lawsuit doesn't make sense in given the novation. So would now so you could then basically file a motion to dismiss saying, "Hey, this is basically a cause of action or a claim without basis in fact because this contract provision no longer exists. Now this is the contract and that doesn't add up to the lawsuit. Like the novation could be that the debt is discharged, could be in there, right? If there was initially debt. So then they can't sue you based on the debt if there is no longer any debt.
Yes. I mean, yes. I
Now, I
mean,
know you might want to countersue them and answer with a counterclaims as a different strategy because you can get damages, but this seems to me like it would be a legitimate motion to dismiss if you wanted to simply dispose of the lawsuit.
that's correct. I mean, again, I live in a world where everything I see is horseshit all the time. So, and I'm trying to do something that's very unique that not many people have ever seen. So, I have a very skewed and specific reality on all of this. But yes, that's correct.
Right, because you want your cases to impact the general jurisdiction, right? Like you want the judges to start looking at things differently, and you want other people to start, looking at things differently, right? You're not just going for your individual justice or the justice for a client you might be involved with, right? You're trying to make a bigger impact. That's why you're doing things maybe a little distinctively.
I don't know where the judges are at. I've had very little actual interaction with judges. It's pretty much just me and the bar cards going back and forth for months and months and months like crazy lunatics. The only judge that's chimed in on anything is the first case, and that case was a bit rough. It was my first one. It was filed in a very crazy way with a lot of crazy things. I wasn't totally sure, and I told my partner Joey, I said that there's only one area in this entire lawsuit that I'm just not totally sure on, and I did a lot of research before I did the case, and it was the area of conditional versus unconditional. Is this a conditional instrument or an unconditional instrument, right? And throughout the entire lawsuit, I was kept looking at the documents, and it seemed good for me. But then that's what the case was thrown out on, was the conditional versus unconditional. So the thing is that the first judge that I contacted on the first case was at least somewhat aware of the commercial code, the uniform commercial code, because she did mention that, and I did go on a very long. I tore every contract out of my apartment, every single thing I could possibly get my hands on. I was reading, I was losing sleep for probably 3 or 4 days, just going absolutely crazy trying to figure out this conditional versus unconditional again. It was like the fifth time I had tried to figure it out. And I had a kind of a breakthrough on it, and I realized, okay, so there's the conditional or unconditional is based off of the payment, and then you have the endorsement, which is an entirely different thing, which can be conditional or unconditional. I had to separate all that out. Anyways, so with case one, I finally realized that we are actually dealing with a conditional promise to pay, and that's why that case was dismissed. But the thing is, all the other cases are not in that same category. All the other cases that we have on the runway that we're filing soon, and all the other ones that are currently on active in the courts, are all very, very clear. That one was a specific situation that is different than all the other cases.
Right. And so this is an excellent learning opportunity, right? Because one, now you know exactly what the difference is and how that defines, negotiable instruments and your ability to enforce negotiable instruments.
Mm-hmm.
So that's an excellent lesson to have. You won't make that mistake again. But, let's also say that there's a couple things. So one is a motion to dismiss can be granted in part. It doesn't have to be complete, right? Because you could have multiple causes of action or claims in the lawsuit. So they could dismiss one claim but leave another standing. Another thing is when they rule on this, if motion to dismiss is denied, of course, then the case just moves forward as usual. If it's granted, it can be granted with or without prejudice. So with prejudice means that's the end of the line. You can't amend your complaint and refile it. It's kind of like double jeopardy in a murder case. But if it's without prejudice, then you can amend your complaint and refile it. And I think a lot of times that is how the ruling goes, especially if it's kind of a mistake that's easily corrected, like improper service of process, for example, which can get a case dismissed, but then they can refile it using proper service. So that would be like a delay tactic, in my opinion.
Yeah, again, they're just trying to throw you off, or to wear you out, or to shiny object your attention someplace else. It's always either how can we wear them out? How can we stretch it out? How can we redirect his attention? How can we? That's pretty much what they're trying to figure out all the time. And you can actually even take the word "attorn." If you look up the definition of the word "attorn," it means to transfer something from one party to another. Or way back in the feudal days, there's actually a feudal definition. It means to transfer allegiance, essentially, from one lord to another, right? So "attorn" literally means to redirect attention, or to transfer objects or assets or whatever from one party or area to another. Literally, transfer. "Attorn" means transfer. Literally, that's what it means.
I think neither of us particularly feel that it's a great idea to hire professional bar cards. But if, just a word out there, because sometimes somebody might find themselves in a situation where the court is requiring them to work with a bar card. So I would say for those people in that situation, you should one ask yourself, am I acting competently in this court case? Because sometimes we can let our emotions get the better of us, or maybe not understand the law very well in the area that we're working in, and make sure that we are acting competently, that we don't actually need that, because the court may be telling us, hey, you're not doing a competent job. And in that case, we want to reconsider what we're doing. But the second thing, if the situation is that you are competent, but the court is just basically being unfair in some way, you can actually establish the terms of the contract with that appointed attorney, right? Because they can't force you to enter into a contract, right? They can establish a contract with the attorney, the court can, but for you to do it, you have to have a meeting of the minds, so you can tell them your terms. Like you could say, I don't want you to speak in court, for example, um, or many other things that would basically allow you to have them on board, but they wouldn't get in the way of what you were doing, because the general relationship is that you're an incompetent, and that they have to do it for you because you can't actually stand up for yourself in court. Now, you don't realize this. You think you're getting, a professional, like a high roller or something like that to work for you, but that's not really the nuts and bolts of what's going on.
Yeah, I actually had a breakthrough in this just a few days ago. Actually, I can share that. So if you look up the definition of the word client in a body called corpus juris secundum, which means second body of law, it's defined as, quote, one who applies to a lawyer, period. Clients are also called wards of the court. Then if you go and look up the definition of this term, wards of court, it is defined as, quote, infants and persons of unsound mind.
I knew you were going to get to infants.
So this is the way it works. So what's happening is that basically what you're doing is you're saying, I cannot communicate myself. I cannot communicate my thoughts. I do not have enough lucidity in my mind to communicate myself and communicate my thoughts at all. I need someone else to do it for me. And that's the whole idea of an unsound mind or an infant. Now, when you do this and you pay for this and you get involved in this particular situation, you become what's called a ward of the court. Now, if you go down that rabbit hole, essentially the way that works is you become property of the court. Okay? And we're talking like this microphone right here in front of me, or these set of headphones, like full blown. What causes these headphones to be my property? The definition of property or control of property would be, well, they're in my apartment. I have exclusive usage rights to these particular headphones. I typically interact with them on a regular basis, and they're inside of a locked a facility called my apartment, and other people do not have access to them on a regular basis. I would need to give them specific access to said headphones, and that's almost like breaking down the idea of property to an absurd level, basically, right? So property of the court would be the same idea. They dispose you, meaning that your disposition. They control where you go and when you talk and that kind of thing. You are literally property, like a box, like an Amazon delivery of the court, right? Now I started going down this rabbit hole of practicing law, or a license to practice law, recently, again, for like the 900th time, right? And I finally had a breakthrough on
People
it.
been saying that you're practicing without a license again,
Oh
Brandon?
yeah, it's hilarious. I'm having a blast with these bar cards. So these shiny objects, they're getting pissed. I don't follow the shiny objects, but I do research, and I do have questions, and I do want to make sure I really understand this stuff. Okay, so I've looked at this a million times, and yeah, I've always had some realizations, and yeah, but this last time, a few days ago, looking at it for the 9,000th time, we finally had a breakthrough on it, right? So if you look up practicing law online, you'll find out that there is no like really, really specific legal solid definition. There's some things you'll find here and there, but it's not fully nailed down, right? Then you take the term license. The term license means permission to do something that would otherwise be considered not allowable. I believe is literally verbatim, straight out of Black's law. Okay, so if you think that a bar card attorney is essentially administering the assets of the court called wards of the court, if you I believe that that's actually the definition of the term practicing law. The definition of the term practicing law is to administer the property of the court. So if you were to say license to practice law, the literal translation of that in a definitional form would be permission to administer the assets of the court, which, if you didn't have this particular membership into this private membership association called the bar, that particular thing of administering the court's assets would not be allowable. And I think I finally understand it now. It's the first time I've ever really totally understood it, because they bring it up in these lawsuits and they just make it whatever they want to make it. Practicing law. It's when you pull a pigeon out of the sky and do an augury on it, and you place it up to the stars, and you find out what's going to happen in 400 years with the orange trees. It's anything. They just make it absolutely anything they want. And the thing is that I finally realize, I think that's what it actually means in law.
So, Brandon, you basically just described the courtroom as a trust entity.
That's
Right,
correct.
because the duty to administer the property of the court, right? That's the trustee's job.
That's
So you're
correct.
saying the attorneys are the trustees of the court. Obviously, the beneficiary is the state, and you're saying we are the property or the res of this trust.
That's correct.
That's
But
pretty
that's
incredible.
only when you take on a bar card, or when you act in a manner that would allow the court to label you as an infant or person of unsound mind. If you go in there and you're screaming and hollering and manifestos and you're threatening the bailiff and threatening the judge, it's very easy for the court, and I'll be honest with you, if I was a judge, I would do the same thing, to say that you are acting of unsound mind. Or if you're throwing a temper tantrum in the court, you are acting as an infant in the court. Do you see?
That's what I was saying before about if are you acting competently in the court? Because if you are having emotional outbursts like that, or name calling or sarcasm even, right, then that's evidence that you're incompetent. But let me rephrase my question, because I know you're saying that you put yourself as the property if you contract with an attorney.
Mhm.
But what if you stand in there as a man? Is it still a trust set up, but you have a different role, or does that prevent this kind of trust from being set up?
It would be a completely different role. There's no, what is the res of what is the asset of the trust at that point.
Well, the asset could be some kind of commercial paper, either depending on, maybe a bond gets established for the case because there's going to be potential damages and such. I mean, I know that some of the forms that the court clerk files are actually, financial statements. So, I mean, I'm not sure, but what else could be the value?
I don't know, and that's something that, I have talked about that before when I didn't know what I was talking about. But now that I have a lot more information as to how all this works, I'm not totally sure how that would be structured at that point. And I would imagine you could just kind of say or do whatever. But the thing is it's not. It's sort of implied as well. I don't, you could just say that the judge has a fiduciary responsibility to both parties. I don't know, that the judge does have a fiduciary responsibility to both parties. I don't know. So I don't know. I mean, I would almost say that you are the executor because you're the one who filed the lawsuit, and then the judge is the trustee, and then both parties would both be beneficiaries. I don't know.
Yeah, so this definitely merits some additional thought, but the main point is that depending on how you deal with the court case yourself, that you're going to be treated differently and have a different role and different outcomes. And, you're certainly giving away a lot by contracting with a bar card. And you can, I believe, you can also implicate yourself in such a contract even without, representation, depending on what how you file the paperwork and what you say. So there are ways to make sure that you don't incur liability that's not actually yours in the courtroom, of course, and then you could be on even footing to actually, adjudicate, or maybe even superior ground, right? Because you really are the highest entity, right, in the courtroom. Especially, you're a higher entity than a corporation, for sure.
Well, if you file the lawsuit, that's the beauty about being the plaintiff. You are the executor. Whether there's a trust or not, or if one pops up, or if it changes, it doesn't matter. End of story. It is you. You're always going to be the executor if you file the damn thing.
That's true.
You paid for it.
Set it in motion.
One of the benefits of being the one to set it in motion is that, but one of the benefits of being on the defensive side is that a counterclaim doesn't cost you anything. There's no filing fees. There's no service of process fees. In a federal case, you're looking at $405 filing fee and $80 for processing if you use a process server. Well, you just saved yourself $485. You can goad them into suing you so that you can have a free lawsuit to counterclaim. That's also another effective performance.
That's not an insignificant filing fee. In federal court, do they allow you to enroll in the electronic filing system?
Of course.
So that then you don't have to
That's Pacer.
You don't have to pay a process server. No, I'm talking about to file your documents, not to view your documents.
No, there's always service of process. Always.
So, I mean, in the New York court system, for example, they have, I got this because I was a pro se defendant, but when I was served with the complaint, in there was an additional form that said, this case has been filed electronically. Of course, they did have a process server serve me, but they said, if you want to opt in to this electronic filing system, you won't get physically served. You'll get it electronically. That's why you have to opt in. But they allow you to actually serve process electronically because their system delivers it reliably to all the parties, and that counts in terms of the for civil procedure law on service of process in New York. So it makes it much more convenient once you are enrolled in that system. If you have, or trust it, and you need to have a scanner so you can upload your own documents, but then you don't have to actually hire a process of server, or you don't even have to file a proof of service document.
Well, I don't. I would definitely look at that again because I've never ever in any jurisdiction the initial summons always is delivered in every single jurisdiction, as far as I know, with some sort of a process server or some sort of physical. And then after that initial service, so you have the initial service, and then right after that initial physical service, then typically everything goes digital from that point all the way to the end.
So that may be true in all cases.
Yeah.
Unless,
if you don't physically serve the initial summons, I guarantee you, and it's probably going to be a long time before we start seeing anything else. I pretty much guarantee you your case will be dismissed for failure to serve.
The New York does allow you to perform service by certified mail.
It's all that is also allowed in California. But even though it is allowed, the first case, one of the reasons why they threw it out, and the judge did sign off on it, was because we use certified mail instead of it's an area that we were doing it that way. We had a lot of issues with it, and now from this point forward, we are going to be using a process server. I recommend that you really research that in a very deep and meaningful way. I've had a lot of issues with that. We have abandoned
Brandon,
that entirely.
I'm not planning to do this myself, but
okay.
I did get served a foreclosure suit by mail and not on a process server. And I was very surprised. I actually, for after I received it in the mail, I was like waiting the next couple of days for every time the doorbell rang or whatever. I was like, oh, that must be the process server. And they never came. And then I looked back in the law and I saw that it is an option, but instead of 20 days to respond, you get 30 days to respond in New York. Now, I didn't challenge it yet because there's sort of a unique process for foreclosures in New York, and I don't have to respond until after having a conference with the opposing party. So I'm
Nice.
kind of waiting for that to happen to feel them out and then decide what I'm going to do. But maybe I could potentially challenge it on those grounds. Like, how, if it's allowed in law, why? What did the judge? How did the judge have a problem with it? What did they say? Was the
I
basis?
forget. It was very complicated. It involved like the actual local rules and stuff like that of civil procedure. It was very annoying and very infuriating. Joey Kimbrough, my right hand man, was dealing with a lot of that because I don't want to get. I try as hard as I can not to get. That's why it's so good if you can. It's so good to have a friend or a relative or a buddy or some kind of a buddy system because my nightmare is getting stuck way down on the minutia of things. That's like the last thing that I want to get involved in, right? Joey is phenomenal with that kind of stuff. I'm not talking about good. I'm not talking about excellent. I'm talking about phenomenal. Okay, so he's the yin to my yang. These big, freaking huge monster. What would you call it? Like saber in the air, horse. Up on the front two. That's kind of where I come in, right? That's my thing, right? And then I want the big, huge picture, the lights, camera, action, the morality, the huge monster, like that's where I really enjoy and I shine, right? But when we start getting into this stuff like local rules regarding service of process, I'm just like, I just want to like rip someone apart with my bare hands. You know what I mean? So the thing is
I
that
agree. I
I
agree with
feel
that.
like it's and the thing is that's where the bar cards will take you, especially when they find out you don't like it. Then they're really going to take you there, right? So the thing is that it's okay. It's okay. I don't, I'm on a show talking about these things. I don't care what the bar cards do. They can try all the horseshit they want because we're just learning from every single process, learning every single thing, learning how to combat these things. So it's not about hiding anything. What it's about if you are like me where you don't want to get down in the weeds of all these things, it's ideal to find a friend or even a loved one or a wife, husband, anybody. It could be somebody in a group or it could be somebody over here or somebody. And I'm not big on like groups more than like maybe two or three people. It starts to just become a shit show so fast. It's so horrible. It's just awful. Like my Facebook group, I tell them all the time. I hate coming in here. I hate this group. I've threatened to shut it down a million times. It's awful, right? It's a little better now. But the thing is that if you have just like one other person or like maybe two, maybe it becomes a whole new dynamic. It's very powerful.
Yeah, I agree. It's I wish I had someone that I could do that with. I have reached out to a couple of folks, but it's a kind of a commitment. So I guess if anyone's out there,
Yeah. Yeah, as more and more people, I get a lot of people calling me. As more and more people doing this, we're going to start seeing more quote unquote super groups popping up, right? And I went through another guy who screwed me over real bad, who I was going to do some litigation with, and he fucked me over and stole some money from me. And then I found Joey, and then I was not interested in getting involved with anyone. It's like going through a bad breakup. I was very, very defensive. I was talking to Joey almost every single day. He was sending me videos. He was sending me videos of a breakdown of his cases. He showed me how to get into Pacer. I didn't know how to get into Pacer at that time. I was downloading his documents, looking everything over for probably about 6, 7 weeks. and then at that time is when I had my first client, and things were going south super fast, and we needed to file litigation like today. And then that's when I pulled the trigger with Joey, and then Joey came in with me on case one, which had to be, it was a kind of a scramble to put that one together. All the other ones were very careful and very meticulous. So, you have to put your feelers out there, and it might take a while to find someone that you can work with, but you find someone that complements your concerns and your style, and it's very powerful. Like, for example, I don't think I'd really be able to do any of this without Joey. Joey is absolutely critical aspect of my operation.
Well, it's fortunate it worked out that way, certainly. And it sounds like it was just at the right timing. So, I think a lot of times when we're on the path trying to do the right thing, that's what happens, is that the opportunity, the right person, the right circumstances occur,
Yeah.
in the favor of the good, when they're supposed to.
Yeah.
So we've been at it for a while. Do you want to get into summary judgment motions at all, or kind of talk about what discovery is?
Um, I'm several months, 3, 4, 5 months into my cases, and we're just kind of barely knocking on those doors. For most people, it's not really something. It's kind of like talking about something that most people aren't going to be seeing anytime soon, and most people are kind of more interested in just the front end of all of this. But just to give a little tiny bit of information, it's all theoretical. I haven't gone through it myself. Is discovery is just the way I look at it is the court issues you a badge, a gun, and a shovel, and that's the simplicity of it. It's very, very simple, right? You're asking the court for basically to become essentially a deputy of the court. Not really, but you get the powers of being a deputy of the court. Now, what do these various powers give you? It gives you the ability to force someone into a deposition, which means that they have to answer questions on camera under penalty of perjury, which is jail time, sanctions, pay money, all sorts of good stuff. You can force people to answer questions under penalty of perjury. That's called an interrogatory. You can force people to produce records, documents, papers, emails. That's called I forget the exact term. Admission, something admissions or something. I forget. There's an exact term for it. So again, you have a badge, a gun, and a shovel, and you can even file, let's say, subpoenas. Let's say there's a third party. Let's say there's a party way over here, and they have information. A banking institution that let's say there's a financial transaction that ping ponged over here to
Federal
this
Reserve.
whatever, Federal Reserve or whoever. You can write a subpoena. So basically what you're doing in the subpoena is you're saying, I've been granted the right to use the power of this court. Under the power of this court, I hereby order you to provide this court the following information or documents.
Right. It's a police
That's what a
power,
subpoena is.
because if it's violated, right, if a judicial or a court order is violated, then it's contempt of court, which can be even a felony level crime in most states.
So when you move into discovery, you are basically literally a detective. You are law enforcement. You are a detective, like an NYPD detective, like these cool TV shows, the Law and Order and all this. Literally, I'm not kidding when I say this. You are literally being issued a badge, a gun, and a shovel. You are a detective when you get into discovery. That's the simplicity of it. Obviously, the whole point is to dig up the truth and to place that truth into the record of the court. And when you start doing that, and if you're able to get a case into discovery, it's you're going to have, if you're the plaintiff, the defense is going to be sweating. And as soon as you place one really key piece of evidence into the docket through discovery, typically that's when, from all the research I've done, again, I haven't done it myself, that's when the tides start turning. And now all of a sudden, all your bar card friends that were trying to do the shiny objects and the titties and the fountains of whiskey and the desert illusions, all of a sudden they're your best friend. and they want to jerk you off, and they want to buy you ice cream, and they will pat you on the back, and they say that you're such a handsome guy, and the gait while you walk is so masculine and strong, and it's so impressive, and wow, you're such a great guy, and I was really wrong about you, and now all of a sudden they're your best friends. And that's when, typically, from all the research I've done, that's when we start getting into talks of a settlement.
So this is key because, and by the way, this works if you're a plaintiff or a defendant, if you're coming from the position that you're going to argue the real law of which the other side is unfamiliar with, because during discovery is when you're going to get access to those banking records, for example, that are going to show, where the funds actually came and went from. And they don't want that to happen. So with the summary judgment, and the reason why Brandon was saying most people aren't there yet is because normally what happens is you go through discovery, and then one side says, hey, they didn't get enough facts to actually make their case at trial. So we're going to now file a motion for summary judgment and say, just settle the case in our favor right now because the other side didn't get anything. They don't have anything to go forward. But in my case, what they did is they filed for summary judgment before discovery because they don't want discovery to happen. They don't want their records to be exposed, and they know that I'll have that police power. So they're trying, as much as they can to get a default judgment and not enter into discovery. And this is, I think, relatively easy to defend because every state that I've looked at in the federal rules of civil procedure all have a specific rule that says, if discovery would uncover a fact that would make the case triable, in other words, an actual dispute, well, then you can't grant summary judgment motion until after all the facts are entered into evidence and discovery is completed. So they are basically saying, we're going to just hope that he doesn't realize that you can use that defense, to get rid of it. But they don't want. So if in any cases, if you face a summary judgment motion before discovery, then what is that the other side does not want to go through into discovery. And so you can ask the question, why is that? And then that will give you clues in how you can defend against that motion. I mean, most likely, all you have to do is say there are facts in dispute, because if there's facts in dispute, then you need to move forward to resolve those disputes with the trial. So, but it's important to see that why they're using that tactic.
Yeah, and the thing about discovery that needs to be considered very important is it's a double-edged sword, because when the court is moved into discovery, both parties, the plaintiff and the defendant, really all parties, there could be multiple plaintiffs and multiple defendants, everyone is issued a badge, a gun, and a shovel. So the thing is, you have to realize, so if there's
Like
two parties,
affairs.
if there's two parties, both parties are going to be issued badges, guns, and shovels. So the beauty of a financial situation, any loan, any quote unquote loan, any student loan, business loan, credit card account, car loan, these loans, that's why I specialize in these areas, because when you understand, I don't want to get into all of this on this show because I just want to try to stay away from going down this deep financial rabbit hole. But when you understand how the things are funded, and you understand how the things work, and you understand how these things are swapped, and how the thing is that you have literally absolutely nothing to hide. I mean, we're talking they could be issued body armor. They could be issued the special agents of the Internal Revenue Service and the whole planet could be rallied and trained as a militia to come after me. I'm not even going to have one bead of sweat coming off my head. Whereas they are in seriously deep shit when I get my gun, my badge, and my shovel. I mean, they are in they are in boiling water that's so hot and so toxic that they don't stand a chance. Now that's a beautiful situation.
I already put all the evidence I have. It's already put in.
A lot of times the defense puts in all my evidence for me. I don't even need to do anything, literally.
That's right. That's right. What can they get from me?
There's nothing. There's not a damn thing.
But what are they hiding? They're hiding an awful lot. They You
Yes.
know, I mean, in one of my foreclosures, they didn't even put in an endorsed note.
Correct.
They just put the note with only my signature. I mean,
Correct.
why would they not want to put in the actual evidence?
I've seen cases where they literally put in the endorsed note and they incriminate themselves by putting it into evidence. Hilarious. These people don't have a fucking clue. It's hysterical. It's literally like I laugh because a bar card is supposed to present on behalf of infants and persons of unsound mind. They are infants. It's infants that are it's infants that are with infants. It's just a giant. It's a giant kindergarten. They're
That's right.
infants.
Because if you sue them, let's say you sue an attorney for malpractice, for example, what are they going to do? They're going to hire another attorney
That's right.
and make themselves an infant.
It's literally, and that's why it's so funny because when you first start getting into all this, you see the big suits and the big wooden whatever, and you go through the security, and then there's the bailiff, and there's guns, and it's like the whole thing is just an illusion because when you realize really what you're doing is you're walking into a playground with a bunch of autistic children, and they're playing with sand and building little sandcastles, and they're horrible, horrible sandcastles. I mean, you're looking at the sandcastle and you can't even tell that it's a sandcastle. It's like a mound of what is that? Is that a I don't tell me. And they look at you and they say something incoherent. Like they look at you and they say, "Oh, this is actually a Snuffleupagus." And you say, "What's that?" And they go, "I don't know." And then they go back to building whatever you can't tell. That's literally what you're dealing with. That's the level of what you're dealing with. And when you realize that, this anxiety and this fear and this terror and all these things start to subside, and you get to a certain point where you can't help but just laugh fucking hysterically at everything they file.
That's right. And if you inject a little bit of sarcasm in your legal writings, like that could actually be appreciated even by the judge. You have to do it tastefully, but because some of these things are so preposterous, right? Like we're in this whole suit that kind of about, is there what really happened with all the money? What are these payments? Do they count? What's the legality? And then they say, oh yeah, we didn't check the mail. It never came. Mail never came. My dog ate my homework, right? Stuff like
Yeah,
that. That's it. Once you just
literally.
can read and understand what they're writing, that's what you see. The dog ate my homework, therefore, pay me $1 million or let me out of my, fraud or whatever tort they're defending. So,
Yeah.
this is you're in a good position if you're not going to be scared and intimidated and run away and you know, maybe don't get involved in 4 lawsuits at one time like we do if you don't want to be overwhelmed, but you can handle one.
I say it's good to have a few. The reason why I say it is because you don't want to get too caught up in one. You don't want to get too hung up on one. You don't want to get too nervous about one. It's sort of like the affluence versus it's like abundant. It's like natural abundance versus scarcity mindset, right? If you have 3 cars, if one breaks down, it's like, it's not the biggest deal in the world. If you've only got one car and it breaks down, it can be a real issue. It's like your whole life is collapsing before your eyes. So I actually think having like 2 or 3, if you can, especially if you have a partner or someone else that you're working with, I think 2 or 3 is a great way to start because, and this is coming from a guy who's got like 6 or 7 now. I had 4 pretty fast, and now I've got 6 or 7. Um, there's huge, massive time periods of absolutely fucking nothing.
Yeah,
I mean,
that's true.
I mean, like a dust bowl. I'm talking like from probably March until May or June. Recently, everything kind of all exploded all at once, and it's been absolute madness. And like 7 different suits and a whole bunch of new ones were filed, and it's just a madness. But I'm telling you, from February all the way up till now, the first initial 4 suits. If it wasn't for this whole explosion and all these new suits and all this craziness going on here in the middle, I could probably take on 12, 14, 16, 18 lawsuits. And we're talking way, way, way less than a part-time job. If you really amortize all the time over an entire year, I mean, uh
You got to be really efficient and organized to do that because you're right. There is like a lot of time when just nothing at all happens in these cases. But everything can happen suddenly. And if it happens like that in 4 or 5 or 6 cases at the same time, you could
That's what I'm dealing
be
with.
overwhelmed. So
Yeah,
you got to like
I'm
draw up
very,
all your
I'm a little
documents
bit
ahead of
tattered.
time.
Yeah, it's.
But we're trying to say that this is something that any competent man or woman can do if you're interested in this, if you want to uphold justice for yourself personally and your family, and if you're willing to do a little work, and if you have to, usually, I mean, I don't think we may not ever or hardly ever have to actually step foot and make an oral argument in a courtroom. It's mostly all on paper. But you do have to be ready and willing to go in there and stand up for yourself in the courtroom as well. So as long as feel that you can do that and, not break down and have a nervous breakdown uh or act like an imbecile, then, this is totally attainable. And really, this is part of being an adult, because there's no way we can go through life and avoid legal entanglements, right? Obviously, driving the car, professional licenses, even with your kids going to school or being forced to
Mhm.
go to school, your marriage, death, wills. I
Forced
mean,
medical stuff. Now we have to deal with that.
there's no way to avoid it. And, where most people are completely ignorant of what is going on and what they are agreeing to, how they're agreeing to it, even when it's against their best interest, because often when you agree without knowledge, it is going to be against your best interest. But also that this system of commerce and contracts, it's actually designed to be to your benefit, and you can work it. You don't have to, live out in the wilderness, eating dirt. You can be part of the system. You can have fast motorcycles, right? Fast women, lots of booze, right? Like I'm talking high shelf cognac.
Oh my god,
Um,
it's so fucking funny.
and that's the way, it's really meant to be. Obviously, not just in a hedonic way, but in a meaningful way, right? We should use these resources for good, like teaching you all how to stand up for your rights.
Yeah, and this is typically the part, or actually probably about 15, 20, 25 minutes ago in the show. This is typically the part, or that's typically the part where people start going, "Oh, this is all so complicated." And it's a very interesting conversation because people, everything is complicated. Raising a children is baseball. So think about baseball. So you have this ball, and it has to be all these certain dimensions, and it has to be a certain color of the thread of the thing, and it has to be tied around in a certain way, and it's got to be a certain shape and a certain density and a certain sponginess that this other guy who has this big leather thing on his hand that comes up about yay high. It probably has all sorts of rules and dimensions as to it can only be this big and this small and this wide and this material. It's got this area of webbing here between, and he's got these shoes, and the shoes have these metal prongs that go into the ground, and there's this mound in the middle that has this exact and direct measurement from this mound, this mound, this mound, and this mound. It has to be an exact thing, an exact a curvature, and then an exact height. It's all very specific. And then he throws this thing, and it's going towards this other person who has this piece of wood or piece of aluminum that has to be an exact size, an exact shape. It has to be hollow. It's X amount of millimeter thickness. Okay, he's got this side helmet thing on, and then there's this guy with this cage thing across his face, and it's got certain dimensions and laws and rules, and he's got another one of those crazy looking glove things, and then there's this box on the ground that the guy with the bat has to stand inside of. And if he gets too far over here or too far over here, and it's 3 3/4 inches by three, you start to really break down how there is a rule structure here. And you start to break down, it's actually terribly complicated. Horribly. You throw the ball for some reason. Why is it first base? If the first baseman catches the ball and touches his foot on this little piece of square with a little triangle at the top, why is it on first base they're out as soon as he touches the base? But if it's second base or third base, it's not instantaneously out. The guy can turn around and cut bait and go back to the previous base. And it's just like, it's like, and then there's if you catch it, and if you catch it this way, and if you throw it, it's like, oh my God, it's like people don't realize it's madness. It's so complicated. It's
That's a
so
great
fucking
example.
complicated.
Such a great example. There's nothing in a courtroom that's more complicated than the infield fly rule.
Oh God. Football. Don't even get me started. It's so fucking complex. It's unbelievable. People think like, oh, it's so simple and they just and drink beer and all this. No, it's like they have these books of all these different things and they name all these things and they go this direction and that direction and the lineman and there's the hut hike and the 8626. It's like, oh my God, it's like crazy. It's insane.
Maybe we should have like spectator courts because, like you could sit around and drink beer and watch people argue it out, right?
Yes.
I mean, you'd want people
Yes.
though who are skilled,
Yes.
right, to
This
make it
is this is
entertaining, and
well,
would
they
have to
do
be
this
at the top levels.
with the big celebrity cases. They do this. They televise like the
That's
O.J.
true.
Simpson cases and the Michael Jackson cases. And if you think about it, Pacer is, like I said, it's a public octagon. That's what it is. It's all written now. It's all reading. So it's sort of
I
like,
wonder if I wonder if you can like take a production company and like dramatize it.
of
Like go
course.
through there, find
Hello,
interesting
Judge Judy, my
cases.
friend.
That's what?
Judge Judy.
Well, yeah, but Judge Judy, it's about such mundane things. You could make this about real substantive issues of law.
1,000%. Judge Judy. I mean, Judge Judy ran forever. Everyone knows Judge Judy. Everyone loves the show. Judge Mathis. When I was growing up, we had Judge
Well,
Mathis, Judge Judy,
who was the first one on the People's Court? Do you remember
the
that
People's
guy?
Court. I vaguely remember the People's Court. Judge Judy was more like my childhood,
Yeah, well,
but
I guess I'm older than you, Brandon.
yeah, a little bit, just a touch. But yeah, it's a situation where yes, of course, the whole premise of a court, if you really want to break it down to its ultimate simplicity, is two adversarial parties agreeing upon a referee. If you really want to break it down to its extreme simplicity, that's all it is. So you say to yourself, "Oh, it's a real court versus a non-real court." If you go to a marriage counselor and you say, "I'm having trouble with my wife," and the husband agrees that this particular counselor is going to be the referee, and the wife agrees this particular person is going to be the referee, they literally have just entered into a court. They have a court. That is a court. It is a court. Because then when the judge or the counselor turns to the man and says, "Listen, Jim, you're being a little bit ridiculous when you throw glasses across the room in the kitchen when you get mad." What he's saying is it's summary judgment. He's saying, "You've given me the authority to be the referee in the situation, and I'm telling you, and I'm giving you summary judgment in this moment to say, quit throwing fucking glasses in the goddamn kitchen, you stupid fuck." You see what I'm saying? It's the same thing. It's literally the same thing. It's the same exact thing.
It's amazing how these, legal concepts that we talk about, right, actually play out into everyday life. In fact, I just developed a little free document explaining the basics of trust law. And I use some examples like that. I think I talk about a doggy daycare as an example. And I'll put a link in there so people can find that. But, you know, all the time, like you already know really about these different kinds of relationships and aspects, right? Like we know, even though we might not feel comfortable reading a contract or writing a contract, like a legal contract, we know what that is because I mean, like we have a contract to do this show today, right? And all we
Mm-hmm.
did was, I called you up and say, hey, you want to do a show, on this or that, and you said, yeah, yeah, bro, I could do it this date, and all of that is just a contract law, right? Now, if you didn't show up, I could potentially take you to court and sue you for breach of contract. Um, and I'd love to sue your ass in court, but no. But fortunately, you showed up, and so there's no dispute. You fulfilled your contractual obligations there.
Yeah.
But really, you can see this stuff in day to day life, and it's just the language, right? It's the same thing that I talk about in medical research and stuff. The reason why people can't sit down and look at scientific papers is because it's written in a different language, and law is written in a different language, and you need to get over that and just get a dictionary and start understanding, okay, I need to learn this new meaning of this word, even though it's a two-letter word that I've known my whole life. It means something different here, so I got to learn it.
Mm-hmm.
And so you got to get over that, and of course put in a little work. But same thing in football, you had to learn a new vocabulary to learn football,
So
baseball, and
much.
all these other special areas of interest. And it's like there has to be a specialized language, because otherwise it becomes inefficient to talk about these things using circumferential and verbose language, right? So, but then you'll be in the club. Once you know these things, you can talk about it, you can understand it much more easily. The same thing is true in the world of finance, right? And if you want to be an investor or entrepreneur, you got to learn those words. So there's no kind of escaping this. Brandon, I'd like to wrap this up a little bit. What do you have coming up that you want to tell people about, or how can people support you besides, of course, doing your amazing free course, the Contract Killer course?
Real quick, right before the show, I had a big bell went off in my head, and I wanted to share it here on the show because it has a lot to do with what we are just talking about. I developed, I'm always developing new definitions for things based off of realizations, based off of different things. And sometimes I just find it very fascinating. And I came up with this definition of the word authority. And I have this definition. I think your people are going to love it. The way I defined it, and it was literally right before I came, it was like 1 minute before the show, and I had this thing, and I in my head, it's a gift from the governed of the ability to lead, born from trust in another person more than there is trust in yourself.
Wow, that's like the psychological concept of the grandiose other.
So I like that because that plugs directly into the whole idea of what is a judge. A judge is someone who you have granted permission to lead you based off of your reasoning that they are trustworthy or more trusty than yourself. Well, the judge thing is a little bit weird because the judge thing, even if you do trust yourself a tremendous amount, you're still, what you're doing is you're asking for the court holds a tremendous amount of illusionary power. And what you're really doing when you file a lawsuit is you're requesting access to the illusion of power. And when I say illusion of power, the reason why it's an illusion of power is because when you understand the definitions of words like person and you understand the way that the financial system works, they can't put you in jail and they can't charge you any money. They actually have zero ability to do literally absolutely anything to you whatsoever. But the thing is that until people take the time and energy to realize all those different things, there is this illusion of tremendous power. And what you're doing is you're basically petitioning or requesting to tap, use, and to dispose of that illusion of power.
Well, that's awesome. And that is exactly what I'm going to talk about in this workshop that I will be doing, which I can't remember the title of, but essentially it shows that, it's like, why isn't it your duty to pay? I think that's what I'm calling it. Right? Because it tells you that when, in this court situation, you're actually not the liable party. And that means,
Yes.
that they don't have the authority to take your freedom away, or to take your assets away, or property, unless you willingly grant it to them. And many people do that unwittingly, not realizing there's an option. But that's what we're talking about. That's what I'm going to be teaching, the basics of how to achieve that and let the court or other parties know that you're not the liable one, and that you still can get justice, or they can get justice if that's appropriate, but they're not going to get it based on your sweat or your loss of freedom.
That's correct. And I guess just to go back to what you mentioned earlier, like anything I want to direct people to, if you have any sort of financial interest, or if you have any sort of financial concerns, or if there is any financial litigation where you're either the defendant or you'd like to be the plaintiff or you are the plaintiff, I have recently done a series of videos that are all available on my YouTube account where we go through each individual section of UCC Article 3, which is basically, as far as I'm concerned, the Bible of what you would consider financials. Okay. The first five parts are all completed. Part 6 is the only one left that I haven't done yet, which I'll do in the next few days. So, or handful of days. So if you have an interest in that, I would definitely take a look at that. It's a bit more on the advanced side, but if that's kind of where you're at, and you're watching a show here with myself and Dr. Kaufman about litigation, you're probably going to be a little bit more in that category. If you're not in that category, then I have a lot of videos on my YouTube. I have a free contract killer course which goes into all sorts of things in a very slow pace. It was done a couple of years ago. I have a free book on my website in text form called the State National Theory Page, which can be read. All sorts of good stuff, all on the greatest website in the world, onestupidfuck.com.
Definitely do spend several hours navigating the stupid fuck website, because really there's just so much information. Like you could actually just go there before you go to a legal or statutory database, because he's got so many of the relevant statutes there, and you can go look up their primary source later. So there's excellent resources, and I really appreciate you covering, negotiable instruments law, right? Which is what's Article 3 of UCC, and it's
Yeah.
something I've spent a lot of time studying it as well. And I will be teaching more on that subject in the future. So my material that I mentioned, the Understanding Trusts free PDF and video, that's at a pretty basic level, but it still might solidify some points for people already with knowledge. My workshop is going to be applicable for people just getting into the material and more advanced people, because it sort of looks at a higher level of what our true role is in the legal system and in the system of commerce. And you can apply that to all your other knowledge, how you go in court. It's really the same way that Brandon goes into court when he works with clients. And which is why he goes in there without any liability himself either. And the client shouldn't have it either. They just have the relationship with a different party. And that's what I'm going to all explain. So we'll have the links to all of these resources in the show notes, so that you can go right there and take advantage of all our free educational materials in this area, so that you can start standing up for yourself, doing the right thing, taking action, and living a truly independent and abundant life as much as that's possible. And of course, always cooperate well with your neighbors, and develop networks of people and communities, and do it on your terms.
Yeah, and one caveat to that is like I said before, people typically say all the time it's too complex, it's too much. I can't. You have already learned so many things in your life that are of the same complexity of what we were talking about, or even worse. The problem is that law and legal has so much emotion wrapped up in it, and so few people know anything about it, that you haven't been exposed to a lot of it, so it seems very novel and very new. Baseball, on the other hand, is so prevalent and it's so everywhere that you've learned the rules. Even if you don't even like baseball,
Right.
you know the rules of baseball.
And
This
they
is
make
just
you play
something
it
where
when
you're
you're a
gonna,
little kid.
yeah, this is just something where you're going off the beaten path. You're going to learn something that very few people know anything about. Yeah, you're not going to be able to get with all your buddies and drink beer and talk about it necessarily. Sometimes you can. I mean, everybody around me wants to talk about this stuff. So
Yeah.
but the thing is that this is not anything worse. The only aspect to this that could be considered quote unquote worse than most other areas in your life that you have had to learn, besides raising children, which would definitely have a lot of this involved in it, is the emotional side of all of this legal stuff. Which, if you've ever raised a child or had a child, you've already been through way worse emotional shit than you're ever going to experience with legal. So the thing is that this is not some totally crazy, unique thing that only superstar, rock star, whatever people can get it. That's not what this is. This is a day by day. Take it slow. It's not going to happen overnight. You're not going to file a complaint and then have pixie fairies flying through your window to carry you off in a never land with Peter Pan. That's not going to happen. You're going to go through the same pressures, the same failures, the same disappointments that you would in any other area of your life.
That's right. But in the end, I think it's going to be, to your betterment, to your advantage. And it's something, that I think we just have to face up to some of these things. There's no way around it. I do, I have talked about equanimity, and that is an important principle. So to undertake this, you have to develop yourself to a point where you can deal with the emotional aspects, that you're not going to, just freak out with fear, because they're going to try and push those buttons. And
Mm.
so you have to, just be prepared for that and take the deep breath and say, okay, I see what they're doing here.
Yeah, they want to make you an infant or person of unsound mind.
Absolutely. Brandon, it's really been a pleasure. I think that, you brought so many important teaching points to this discussion. I really appreciate you and everything you're doing. And,
Thank you.
that there's someone sticking up for everyone with this degree of enthusiasm. And obviously, people are hearing your message. You're spreading like wildfire. So please
Yeah.
keep things going full speed ahead. And I look forward to our next time we get to spend together.
Thank you. And thank you as well.